Welcome back. In the last sessions, we learned about reference, review, revision, and appeals. Okay, let us say you get a decree and the defendant prefers an appeal. He loses there in the first appeal, second appeal, even before the Honorable Supreme Court in special leave petition SLP. And now, after all the remedies have been exhausted by the other side, you get a time to execute the decree. Sometimes if the appeal is not preferred and no stay is granted in the appeal, then you can proceed with the execution of decrees and orders. Okay, friends, this is this is the biggest topic in civil procedure code, the execution of decrees and orders. Okay, the Honorable Supreme Court has commented that it is the biggest trouble of the decree holder to get his decree executed before the courts because of the cumbersome procedure contemplated in the civil procedure code. Okay, friends, a person in whose favor the decree is granted is called the decree holder. Okay, and against whom the decree is executed, he is called the judgment debtor. In short, decree holder, DHR, judgment debtor, JDR. Okay, friends. Now, the chapter execution has been dealt with by sections 36 to 74 of CPC and order 21 of CPC. Okay, these all together guide you how to execute, both the advocates as well as the courts how to execute a decree in various suits. Okay, first section 36 says that all the orders can be executed as the decrees can be executed. Okay, decrees as well as orders can be executed. This is the purport of section 36. Okay, friends, I am dealing with only important sections, not all the sections. Okay, for the purpose of practice. Okay, section 39. Section 39 says that on the application of the DHR, a decree can be transferred to another court. Okay, this application has to be moved before the court which passed the decree, requesting the court to transfer the decree to another court where the JDR resides or the property of JDR is situated for the purpose of execution. Okay, for the purpose of executing the decree. Okay, friends, and section 46 talks about precept. Precept is a certificate or the endorsement of a court which passed the decree to the court where the property of JDR is situated. Okay, for the purpose of attachment of that property. Okay, precept issued by the court which passed the decree will be valid only for 2 months, and from time to time the DHR has to apply to the court which received the precept to extend the attachment. Okay, the attachment will be forced for 2 months only, or until the decree is transferred, or until the attachment is extended from time to time. Attachment is nothing but it's a guarantee by the court that it has seized the property, movable or removable property of the JDR for the purpose of execution of the decrees. Attachment is made only for the purpose of execution. Okay, this is called precept. Okay, friends, section 47 of the CPC says that all questions arising in execution petition between the parties to the EP or the representative shall be determined by the executing court itself, not by a separate suit. For instance, and a representative, in the explanation it is given that representative includes, the party includes a purchaser who purchases the property in an auction in a court. Okay, and the plaintiff whose suit has been dismissed is also included in the definition of parties in this section 47, and the defendant against whom a suit has been dismissed is also included in the definition of parties under section 47 for the purpose of 47. Okay, All the questions, no separate suit between the same parties or the representatives. Okay. Section 49, transfer of a decree. If the DHR transfers a decree to another person, he is subject to all equities which can be agitated by the JDR against the original judgment debtor. This is the purport of section 49. Okay, friends. Section 51 of CPC says how a decree can be executed. A decree of a civil court can be executed by delivery of the immovable property. Okay. B. Attachment and sale of immovable property or movable properties. Okay. By arrest and detention of JDR in civil prison. Okay. D. Appointing a receiver for the management of the property involved in the suit. And the decree can be executed in any other manner according to the nature of the relief granted in the decree. Okay, friends. These are the only modes. Okay, friends. Section 55 of CPC says that when you want to arrest a JDR, you can arrest JDR on any day at any hour. But you can't enter into a dwelling house for the purpose of arrest after sunset and before the sunrise. Okay. Unless you have suspicion that the JDR is hidden in the dwelling house, you can't break open the outer door. If you have any suspicion that is then you can break open the door. And when once you enter into the dwelling house, that is the process server of the court, enters into the dwelling house, he can automatically enter into any room of the dwelling house, and even he can break open the rooms of the house. Okay, to find the JDR. If that dwelling house is occupied by a woman, you can't enter into the house without the permission of that woman or giving sufficient time for that woman to get away from that house. Okay, that after the arrest is made and the JDR is brought before the court shall give an opportunity to the judgment debtor to file an insolvency petition within 1 month. Okay, if he doesn't file any insolvency petition before the appropriate court, then the civil court, executing court can send him to detention, civil prison. Okay, friends. And section 56 of CPC says that no woman shall be arrested in a decree for payment of money. Okay, in money decrees, no woman shall be arrested. Women are exempted from arrest in money decrees. Okay, friends. Friends, section 58 says if the JDR is arrested and he has to be detained in civil prison, the period has been mentioned in section 58 up to which the JDR can be put in the detention of civil prison. Okay, if the amount of the decree involved is less than 2000 rupees, there is no detention. He can't be put in civil prison. Okay, friends. If the amount of the decree is more than 2000 rupees and less than 5000 rupees, the JDR can be detained in civil prison for 6 weeks. And if the amount of the decree is more than 5000 rupees, the JDR can be put in civil prison for up to 3 months only, not beyond that. Okay, friends. If the JDR is put in civil prison, he can't be rearrested in the same in execution of the same decree. Okay, friends. And if the decree is not satisfied even by the arrest and detention of the JDR, the DHR has to adopt to the one of other modes of execution of decree. This is section 58. And section 57 says that you have to pay, DHR decree holder has to pay the subsistence allowance for the time to detain the JDR in the civil prison. It is not borne by the government. The DHR has to bear those expenses. That is called subsistence allowance. Okay. 58. Section 59 says that if it is found that the JDR is caught by illness, he can be released. And if he is cured, then he can be again rearrested and detained in civil prison for the remainder period of the detention mentioned in section 58. Okay, friends. Section 60 says that in execution of decrees, anything can be attached. Anything can be attached, like houses, properties, immovable properties, movable properties, promissory notes, decrees, debentures, Okay, government securities, etc., etc. Everything can be attached in a decree in execution petition. Okay, and exceptions have been given in the proviso to subsection 1 of section 60, like wearing apparels of JDR, cooking vessels of JDR, bedding and carting of the JDR and his family members, and a portion of agricultural produce, and the properties of his servant, agricultural implements, and the houses which are meant to store the agricultural implements, and the rooms or houses meant for the agricultural labor of the JDR or the domestic servant of the JDR, etc., etc. Okay, friends, and I deal with only the important one, that is the salary. Salary of JDR can be attached as per the main rule, sub rule 1 of rule subsection 1 of section 60. But the salary shall be first 1000 rupees plus 2/3 of the salary shall be exempted from the attachment. Okay, not the whole salary can not the whole salary can be attached. The first 1000 rupees shall be deducted, exempted, and then 2/3 of the remainder salary shall be exempted, and only 1/3 of the remainder salary shall be attached in a decree for execution of a decree other than the decree for maintenance. Okay, if that is the case, if the salary of the JDR is attached continuously or intermittently for 12 months, a gap of 12 months shall be given, and again that salary can be attached for another 12 months. That is total 24 months only, and thereafter the salary of the JDR is completely exempted in that decree, not in another decrees. Other DHRs can also go for salary attachment in their decrees. Okay, friends, this is the salary in execution of decrees other than the decrees for maintenance. Okay, clause 1A of proviso to subsection 1 of 60 says that in a decree, in execution of decree for maintenance by wife or children or parents, only 1/3 of the salary shall be exempted, and the total 2/3 salary will be open for attachment. Okay, friends, and the GPF, provident fund, gratuity, policy of amount of policy of insurance on the life of JDR, etc., etc., cannot be attached in execution of decrees. Okay, this is section 60. Read it, you will get interested to read this section. Okay, friends, after this section, section 61, partial exemption of agricultural produce. Section 61 exempts from attachment the partial agricultural produce which is sufficient to harvest in the next season and for the support of the family of JDR and himself shall be exempted from attachment as per section 61. Okay, friends, section 63 says that section 63 of CPC says that if the property of JDR is in the court of a higher is attached by a higher court under the other courts of lower grades, property shall be sold by the court of higher grade. If the property is attached by all the courts of equal grade, then the court which attached the property first shall sell the property as per section 63 of the CPC. Okay, friends, section 64 says that after attachment, private alienations of the property are void. They are void. They are null and void. Okay. Subsection 2 of section 64 says that if before attachment, if the private alienation is registered, then it is valid before attachment. After the attachment, even registration of private alienation is not valid. Okay, it should be sold in the court auction only. Okay, section 65 of CPC says that it deals with title of purchaser. If a person purchases a property in a court auction, in a court auction, in a sale, the title vests with the purchaser from the date of conducting the sale, not from the date of making the sale absolute. Okay, there are two steps. Selling the property is one method in the court, and another is the sale will be made absolute subsequently in the same proceedings. Okay, at the first stage itself, the purchaser of the property in a court auction will get right at the time of sale itself. Okay, friends. Section 73 says that if a court gets custody of assets and more than one person approach the court before it receives the assets of JDR, the condition is before the court receives the proper assets of JDR, then the court shall rateably distribute the assets among, or the value of the assets among all those persons who approached before that court before it receives the assets. Okay, that is section 73. Okay, friends. And section 74 says that when the JDR or their JDR or his representative resisted the delivery of possession to the decree holder or delivery of possession to the auction purchaser, then he can be the JDR or any other person on his behalf may be put in civil prison for 1 month, and the delivery shall be given to the DHR or the auction purchaser as the case may be. Okay, this is the purport of section 74. Okay, friends, in the next video we will deal with order 21.